Our next topic is focused on the pitfalls in invoking the supervisory jurisdiction of the Supreme Court. Our speaker is a justice of the Supreme Court and the supervising judge of commercial courts in Ghana. She has a first degree in law and sociology from the University of Ghana, a qualifying law certificate from the Ghana School of Law also. She holds an LLM in intellectual property law and a postgraduate diploma in international law and organizations for development from the Institute of Social Studies, now in The Hague. She has 18 years of experience in commercial law and litigation. She served as a High Court judge in commercial law and litigation. Sorry about that. She served she served as a High Court judge for 8 years, as a Justice of the Court of Appeal for 7 years, and in 2019 she was appointed to the Supreme Court. She's a board member and faculty member of the Judicial Training Institute, and in addition, she's a commissioner of the Law Reform Commission of Ghana. She's a woman of faith and a minister of the gospel. Ladies and gentlemen, our next speaker is Justice Gertrude Tuckernu. Justice Tuckernu, your audience, thank you.
The general audience out there. Thank you very much, Susan. Uh, when I had 18 years, I was a bit surprised. I think she segmented it because I think put together, I see Professor Bonzi Simpson here. Okay. Put together, I think we've reached 34 years since, we, since we left school. So it's a great pleasure to be with the bar and all the uh, general body of persons who have joined in these lectures. Um, so I was invited to speak or to lead a discussion on pitfalls in applications invoking the supervisory jurisdiction of the Supreme Court. And so that's the discussion I'd like us to have this afternoon. I'd like to begin by drawing, drawing attention to four areas that I'd like us to focus on. The nature of the jurisdiction, the factors that allow the invocation of the jurisdiction. Next slide, please. Who is handling it? Is it possible for me to handle it from here? Or it has to be handled from there. All right. So when I need the next slide, I have to say next slide. Okay. Okay. So so my intention is to consider for us to think about the nature of the jurisdiction, then the factors that allow the invocation of the jurisdiction, then procedures for invoking the jurisdiction, and then the time for invocation of the jurisdiction. Because we are thinking about pitfalls, I think these are the four broad areas that can invite pitfalls. The nature of the jurisdiction, the factors that allow the invocation of the jurisdiction, and procedures for invocation of the jurisdiction, and time for invocation of the jurisdiction. So, as we all know, jurisdiction is always created by statute. Could be the constitution, or would be the constitution, then also the Court Act, and then it may be an add-on statute. So when it comes to the jurisdiction of the Supreme Court, in the supervisory jurisdiction of the Supreme Court, the jurisdiction is created by Article 132, and um, because we are considering pitfalls, I want us to look at it uh, immediately in tandem with the jurisdiction of the High Court, the High Court's own supervisory jurisdiction. So when you look at these two articles, Article 132 and Article 141, you will see that the words are almost identical. Um, so I've highlighted the ones that reflect a bit of change. Article 132 says the Supreme Court shall have supervisory jurisdiction over all courts and over any adjudicating authority, and may, in the exercise of that supervisory jurisdiction, issue orders and directions for the purpose of enforcing or securing the enforcement of its supervisory power. Almost the same words are used regarding the powers of the High Court, but the change is found in the first line. You will see that it says the High Court shall have supervisory jurisdiction over all lower courts, over all lower courts, and then over any lower adjudicating authority. That is different for the Supreme Court. The Supreme Court's own is over any adjudicating authority. The High Court's own is any lower adjudicating authority, and may, in the exercise of that jurisdiction. So the High Court's jurisdiction, the word supervisory has been cancelled from the Constitution. And so these are the differences when it comes to the constitutional provisions. So how have these been interpreted? Um, Before I expand on how it has been interpreted, I'd like us to also look at Article 161, which says the supervisory jurisdiction includes the jurisdiction to issue writs or orders in the nature of habeas corpus, certiorari, mandamus, prohibition, and quo warranto. So these provisions have also guided how the courts have determined which persons can be subject to the supervisory jurisdiction of the Supreme Court. Be, um, and the one, first point I like us regarding factors for invoking the jurisdiction, the first point I'd like us to note is that it has been defined to be applicable to only public bodies. You know, the expression courts and lower adjudicating bodies and adjudicating bodies have been defined to include only public bodies. So if there is a private transaction, or there's a litigation between two private persons, then this relief would not be would not be granted by the court. So in Republic versus High Court ex parte industrialization fund for developing countries, Trum JSC said that I think the second part, it will be useful for us to read the second part from the line 4. It says a private company has no public law functions and it confers no public law rights. Therefore, a party aggrieved by matters emanating from the management and control of a private company cannot invoke the supervisory jurisdiction of the court for redress. In other words, the subject matter of the dispute in the case was not amenable to judicial review, and this court must decline jurisdiction, whatever may have been the mistake committed by the High Court. So in this matter, when it got to the Supreme Court said, even if there was an error, even if there were in the general scope of things, you can find the elements that we will later look at, which could have invited the supervisory jurisdiction of the Supreme Court. We still would not exercise it because the subject matter of the, the litigation, of the dispute itself, is not amenable to judicial review. And so that's one of the first points you need to consider. Who are the parties? We know that jurisdiction is always you need to consider the question of parties, when the capacity of parties or the nature of the parties when you are looking at the jurisdiction of a court. And it is no different when it comes to the supervisory jurisdiction of either the High Court or the Supreme Court. In this case, we are talking about the jurisdiction of the Supreme Court. So the first point is that it's applicable only to public bodies. Then the next factor we need to look at is this factor of nullity. This factor of nullity. Under what circumstance would the Supreme Court allow an invocation of its jurisdiction? What does it look for? It's very, very critical. It's extremely critical in commencing a process invoking the supervisory jurisdiction of the Supreme Court to appreciate that it is necessary for for you to show an absence of legality, an absence of legality that should lead to a nullity. Now, I will expand on that. And then I think I need to backtrack a bit. Apart from public bodies, when it comes to the jurisdiction of the Supreme Court focuses only on the Court of Appeal and the High Court. This is because of the parallel provision in 1414 for the High Court. So the interpretation that has been given to this seeming parallel tracks of jurisdiction is that the High Court is like the fundamental human rights and freedoms. The Supreme Court says as long as it's a fundamental human rights and freedoms, it's enforceable at the High Court. You can't even disguise the suit. He put in Edu Service as Attorney General says you've disguised it in the form, you've put on the dress of original jurisdiction of the Supreme Court, you've brought it to the Supreme Court, but when the dress is taken off, it is actually an action to enforce fundamental human rights, and that lies with the High Court. In the same way, we have these parallel tracks, and the Supreme Court has been very clear that as long as it's a lower adjudicating body or a lower court, then your recourse lies in the High Court and not the Supreme Court. The Supreme Court would only look at issues coming from the High Court or the Court of Appeal because they are superior courts. So, for instance, Trudge, in ex parte Trudge, the decision was that Trudge is subject to the supervisory jurisdiction of the High Court and not the Supreme Court because Trudge is a lower adjudicating body. I think Dr. Bonzo Simpson, you were involved in that one, weren't you? So maybe I should stop now just because I know people may be feeling a bit tired. You've also had lunch. So do you want to give us a mini lecture on Trudge? I should continue. All right. But I really would like to know your thoughts from your experiences, if you can dredge them up. Then, apart from public bodies ensuring that it's only the superior courts, that's the High Court and the Court of Appeal, whose matters you bring up for to invoke the supervisory jurisdiction of the Supreme Court, you must find this element also, the element of illegality which leads to a nullity. Now, what do I mean? I think for years, there had been many cases in which the Supreme Court took jurisdiction over errors of law. And they reached a point where the court said it's time to stand back and ask ourselves, why would we want to invoke the supervisory jurisdiction of the Supreme Court on matters of errors of law of superior courts such as the High Court and the Court of Appeal. Because a court that is sized with jurisdiction, the exercise of that jurisdiction includes the capacity to make a mistake. If you are sitting as judge, then the presumption is you can get it right or get it wrong. And that is why we have layers of courts. So if you get it wrong and make an error of law, should that be a reason why your decision should be quashed? So the court, in a very decisive began to look at the journey of the whole concept of judicial review and what the Constitution of Ghana, the 1992 Constitution of Ghana requires, and that these provisions in on supervisory jurisdiction, and did a distinction that judicial review in this sense, and in this sense of the supervisory jurisdiction, we are looking at a situation where it is not just an error of law, error of law, but we are looking at a situation where the error of law is so patent and so fundamental and so apparent on the face of the record that the decision itself is a nullity. The decision itself is a nullity. Then, apart from the error of law being so apparent, and I'll expand on that, being so apparent on the face of the record, if there is no jurisdiction, then of course, there's the question, the decision would be void, and so the decision would be a nullity. Then sometimes the court has jurisdiction to begin with, but the court may stray into an excess of jurisdiction. And so even though fundamentally the case that is before the court had jurisdiction to begin with, it may make orders, or it may make orders, or it may make decisions that it had no jurisdiction so to do. So let me, I've got the slide up here, but let me expand on these three elements on the face of the record. I think one of the first cases I had to sit on, and I haven't, as you all know, I had to sit on, had to do with the Ladade Kotopom Trust. And in that matter, there was one decision where the High Court judge had to determine who had capacity to deal with the lands, and which family, which something had to do with the family, the line of family. And then after he had properly brought to him that he had jurisdiction on, you know, this omnibus relief, any other relief that as to the court may seem just. This judge then went to take an earlier decision that had been set aside, took the entire decision and said that, I believe that, it was very interesting. I believe that this, in view of the evaluations I've done, this order given by my brother in this earlier decision is a proper order that should be implemented with this case. It may seem incredible, but it happened. So the parties in that suit were not before him. The issues in that suit were not before him. The evidence before him had nothing to do with the matters in that suit, except that all of them were around the same lands, but the issues were different. So he determines the issues before him, between the parties before him. Then he goes and takes that relief and comes under the the relief E, which says as to any other. I mean, you don't need to go into the merits. Are you getting me? You don't need to go into the merits of the matter before you. This is an error that is apparent on the face of the record. And so the Supreme Court quashed that relief. And and the parties came back for review of the decision or something like that. And of course, the answer was that you have no business. It was rightly quashed. But that can be an error, or a situation where the decision is based on a law that has been repealed. So in this situation, you are not looking at the merits of the matter, but you are looking at something that on the face of the record is cannot be granted by the court. Then the next, so we are talking about issues of nullity. All of us appreciate that if the parties before you and the issues before you have nothing to do with that earlier earlier judgment, you have no business going to take the orders from that judgment and coming to tack it on to your own judgment. It made very interesting. Forgive me. I remember feeling extremely confused when I read it. Anyway, so this element of nullity is something that you should constantly look out for. It is the decision, what is being complained of such a nature that this decision cannot stand. It has no legal basis to stand. And one of such factors is the issue of jurisdiction. As for jurisdiction, if you go out of your jurisdiction, we know that the decision is void. Mosi versus Bejina, this is an old established principle. So in Ex parte Soku and another, the court says it must be such an error as goes to the wrong assumption of jurisdiction, or the error is so obvious as to make the decision a nullity. We must also remember that certiorari is a discretionary remedy. I recall that not too long ago, some lawyer friends of mine had been to the Supreme Court with a matter. I was not on the panel, and they were so convinced that the judge, I mean, the judge was functus official, and when she had to pronounce on that, so they were so convinced that that should get them that the problem created could be resolved in a much better way than just quashing the decision. The quashing the decision added nothing to the issues that were before the court. And so the court refused to exercise its jurisdiction. So you should also remember that it's a discretionary remedy. Back to the discussions on nullity. An ex parte industrialization fund for developing countries. I see that nobody is falling asleep, so it's not boring so far. Bamford Ado JSC said, it is to be noted that there's a clear distinction between certiorari and appeal, which is so often lost on litigants and their lawyers. When the High Court, a superior court, is acting within its jurisdiction, its erroneous decision is normally corrected on appeal, whether the error is one of fact or law. Certiorari, however, is a discretionary remedy which would issue to correct a clear error of law on the face of the ruling of the court, such as I described. I mean, the whole thing is so void that it cannot be allowed to remain as part of the record. Or an error which amounts to lack of jurisdiction in the court so as to make the decision a nullity. In the case of errors of law not apparent on the face of the ruling, which is errors that you need to read the whole ruling, it's about the merits of the decision. It may be, the decision may be erroneous, and every day we see them. But if it's an error of law or a failure to give to weigh the facts adequately and evaluate the facts adequately, that's a matter for appeal. So it says it must be, the error should amount to a lack of jurisdiction in the court, such as would make the decision a nullity. In the case of errors of law not apparent on the face of the ruling or those of fact, the avenue for redress is by way of appeal. So I call it the infrastructure. This is the architecture. This is the architecture of it. This is the question that you need to ask yourself. Would this decision be a nullity? Is it unlawful? Is it illegal? Not just that, is it erroneous? Because if it's erroneous, it may be an error that needs to be corrected on appeal, not one that. In ex parte charge, adult interested party, um, after I think, and I would recommend anybody who feels that they need to really get to grips with this business of certiorari and appeal. This is a decision to read. It in typical Datiba fashion, he does a thesis and and evaluates the journey of judicial review through anismenic, right? Yeah, through anismenic, and that's the whole gamut. Goes from Australia to New Zealand, and 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 the whole concept of judicial review looks at what the common law countries have intended to achieve with a remedy, and how it works through the high court, supervising lower courts and lower adjudicating authorities, and then compares it to what the Supreme Court is supposed to be doing with the superior courts. With the superior courts, it's not appropriate for the Supreme Court to be just looking at errors of law. So it has to be extremely narrow. And it is this narrow window that we are discussing this afternoon. This narrow window of nullity, of excess of jurisdiction, want of jurisdiction, or an error so apparent on the face of the record that you don't need to look far to find it. So he does, at the end of his thesis, he ends, I call it a thesis, he ends with a restatement. And he says the restatement of the law may be summarized as follows. Where the High Court, or for that matter, the Court of Appeal, makes a non jurisdictional error of law, which means an error that does not go to the jurisdiction. That's the non jurisdictional. It doesn't go to jurisdiction. Jurisdictional error means an error that goes to the jurisdiction. It makes a non jurisdictional error of law, which is not patent on the face of the record. The avenue for redress open to an aggrieved party was an appeal, not judicial review. In this regard, on an error of law made by the High Court or Court of Appeal is not to be regarded as taking the judge outside the judge's jurisdiction, unless the court has acted ultra vires the Constitution or an express statutory restriction validly imposed on it. Thus, prohibition lies to and I've separated them because this is on the second page. He's moved on into another discussion, but I thought that this was also an appropriate statement for us to see. That prohibition lies to prevent a court from exceeding its jurisdiction or reaching a decision which could be quashed subsequently by certiorari. So, because we know that prohibition is part of the reliefs that's given under the supervisory jurisdiction. Then he goes on to say on the next page, accordingly, if no error is patent on the face of the record within the meaning outlined above, or there's no excess of jurisdiction, it will not succeed. So if there's no error that is patent on the face of the record, like what I described, or and there's no excess of jurisdiction, there's no lack of jurisdiction, then the court would not accede to the application. So far, is it okay, or it remains confusing? All right. So, still on the discussion of nullity, ex parte chachuchikata. And I've heard when I got during my orientation to the Supreme Court, I heard many of my seniors saying that they think that this statement is a clearer expression of the principle than one may even find in ex parte um, ADO, ex parte charge, ADO interested party. They think that this this one it may be a clearer statement. And what is that statement in ex parte Chachuchikata? Ex parte Republic versus Court of Ex parte Chachuchikata Interested Party. This is the clear thinking of the court is that our supervisory jurisdiction under Article 132 of the 1992 Constitution should be exercised only in those manifestly plain and obvious cases where there are patent errors of law on the face of the record, which errors either go to jurisdiction or are so plain as to make the impugned decision a complete nullity. It stands to reason then that the error of law as alleged must be fundamental, substantial, material, grave, or so serious as to go to the root of the matter. So you are asking yourself, does this go to the root of the matter? A minor, trifling, inconsequential, or unimportant error which does not go to the core or root of the decision complained of, or stated differently, on which the decision does not turn, that it's not the pivot of the decision, it's not the basis of the decision, would not attract the court supervisory jurisdiction. So if the judge, there's no want of jurisdiction, but there's an error, but that error does not is not the basis for the decision. So if you look you read the decision, the basis for the decision is not, maybe the judge considered two different statutes and one was repealed. The fact that one was repealed doesn't make it a decision that's amenable to be quashed by certiorari. If you find, for instance, that the statute that the decision turned on was actually or depended on is not one that has been repealed. So it's not a jurisdiction that the court is happy to um, utilize. They do quite a bit of critical analysis before they are ready to engage. It's like the review jurisdiction of the Supreme Court. And judicial review is not the same as review. We know that the review jurisdiction of the Supreme Court is, I think, Rule 54. This one is Rule 61. Mhm. Is that the Supreme Court has seven or so jurisdictions, and this one is under Rule 61 in Article 131. All right. Excess of jurisdiction. This is a case that I was personally involved in and wrote, and I think that it's a good example. Um, and this is Republic versus High Court, who ex parte, Margaret Kwekwe, and others interested parties. I think it was in the news that it affected the people from Sancho Kofi and Lolobi. They called it the South community, and it was about voting. Now, the reason why the Supreme Court quashed the decision of the certain orders of the High Court was because even though the High Court had jurisdiction to deal with the matter, the general substance of the case that was put before it, along with that case was tagged another case. And that other case, the court did not have jurisdiction to do it. What case went to the went to the High Court? The interested parties here went to the High Court under Chapter 5. of the Constitution, they alleged that their right to vote had been violated. And so they brought an application, an originating motion, because under the rules of court, it's allowed for them to go by originating motion. But along with the reliefs was were reliefs that sought to um, declare void the parliamentary, uh, yeah, the victory of the parliamentary candidate of Hohoi, Mr. Peter Amewu. So the parties went to court and said a human right. We allege that the right to vote is a human right. And if the court finds that our right to vote is a human right, the court ought to give us a declaration that the election of Mr. Peter Mewu was null and void. Then they brought, the very day they filed the writ, they brought an application for an injunction to restrain him from being sworn in because they had attacked the validity of the election in their action. And the judge granted that injunction. So he would not have been sworn in. Then the Attorney General came to the Supreme Court and said that the High Court did not have jurisdiction, even though the High Court had jurisdiction to consider fundamental human rights. The High Court did not have jurisdiction to consider the outcome of a parliamentary election outside of a petition issued to attack the parliamentary election by itself. And we agreed. We agreed. And this is why we agreed. And that's why I've set out these constitutional provisions for you to look at. Look at Article 33.1. It says, where a person alleges that a provision of this constitution on the fundamental human rights and freedoms has been, or is being, or is likely to be contravened in relation to him, then without prejudice to any other action that is lawfully available, that person may apply to the High Court for redress. Then Article 33.3 says, a person aggrieved by determination of the High Court may appeal to the Court of Appeal with the right of a further appeal to the Supreme Court. So when you allege violation of fundamental human rights, your rights of appeal go up to the Supreme Court. And that these are your rights. Then Article 99 on the validity of parliamentary elections provides that the High Court shall have jurisdiction to hear and determine any question whether a person has been validly elected as a member of parliament, or the seat of a member has become vacant, or, and then there's a B. Then 2, a person aggrieved by the determination of the High Court under this article may appeal to the Court of Appeal. So you see that the Constitution itself truncates parliamentary election disputes at the Court of Appeal and does not allow it to go to the Supreme Court. So in Republic versus J.H. Mensah, as far back as I think that was 95 or so, or 96, 96, 97, Republic versus J.H. Mensah, the Supreme Court held that when it comes to parliamentary elections, the only way to invoke the jurisdiction of the High Court is by petition, pursuant to Section 16 of PNDC Law 284, the Representation of the People's Law, and that decisions in such cases truncate at the Court of Appeal. Then came the Republic versus Zachariah, something, the Woolensey matter. That's the decision was on the Woolensey constituency. Again, in that matter, the Supreme Court said we must appreciate that there's because of the special provision made for parliamentary elections, you cannot invoke the jurisdiction over parliamentary elections in any other way but by petition. But by petition. And pursuant to Section 16 of the of PNDC Law 284 under Article 99. So this is a special genre of cases. So even though the High Court has jurisdiction over fundamental human rights, the High Court has jurisdiction over parliamentary elections, the High Court's jurisdiction over parliamentary elections is exercised only through petition. And that jurisdiction can only truncate at the Court of Appeal. So if you join the jurisdiction of the High Court in parliamentary elections to fundamental human rights, you're going to have a situation where half your case will stop at the Court of Appeal and half will stop at the Supreme Court. It's not tenable. Secondly, you're also going to have the strange situation where the law requires that you commence this by petition. A petition is a pleading to which an answer, which is a pleading, will be filed, and then there can be a trial. But you go by originating motion, it's only affidavits. So even though to adjudicate or to air your rights under fundamental human rights, you can either go by originating motion in under Chapter 5. You can also issue a writ because under Article under Chapter 5 it says, or notwithstanding any other manner in which a case may be started, notwithstanding any other right, you can start by originating motion. So when it comes to fundamental human rights, there are many ways to commence an action: by writ, by originating motion. But when it comes to parliamentary elections, there's only one way: by petition. So all these distinctions have created the legal position that when it comes to challenging any parliamentary, the outcome of parliamentary election, there's only one way to start. And so what we did was we quashed the decision regarding the parliamentary election and the reliefs. We took it out of the case and sent it back to the High Court for the High Court to adjudicate the fundamental human rights matter. In the same way, the Dade Kotopon matter, what the Supreme Court did was take out the strange order that was tagged on, and the rest, the rest. I mean, that was not amenable to a certiorari application. So there can be excess of jurisdiction. You may have jurisdiction to start with, but you may end. You may veer away from your jurisdiction, or there can be an error on the face of the of the matter. So I think I'm coming to my last slide, and in this slide, I'm on slide 12 now. Please. Invoking the supervisory jurisdiction, what you need to remember is that there's Form 29. So you need to look Okufo Estates versus Modern Science. That was a decision that was arrived at before CI 16. Before CI 16. By that time, CI 16 had not come up with the forms. So the Supreme Court in that matter said, even though it said that the form in which the action was started was sustainable. But right now, there's a form 29, and the rules of court say so. Then the time limits. It used to be 3 months. CI 24 has now changed it to 90 days. 3 months and 90 days are not the same. And I think that I've sat on a matter on which, because I think the application was brought on the 91st day or something, and therefore they were out of time. But if it was 3 months, they would have been within time. So 3 months and 90 days is changed by CI 24. I also would like to state that all of us have, I don't know how many of us are aware of CI 133. The passage of CI 133 is, I think, is a very, very critical. It's done. It brought very major changes to the proceed to CI 47, the procedures of the court. Now, for all commercial claims, Order 58, which used to be applicable to only commercial courts, are applicable. And then, secondly, under CI 133, Order 42 has been repealed. So now we don't have review. The review jurisdiction of the High Court is gone by reason of CI. And I think it's about 2 or 3 months old. It's a fairly new piece of statute. So I would say that that's all that I have for you. Thank you.
Thank you very much, Justice Torkornoo, for that enlightening discussion. There's currently one question in our inbox, but a reading of the question, which I'll do, shows that the writer must have been a little bit lost somewhere. So he says, "My lady, with your indulgence, is it not a mark of inelegance to just cross out the supervisory jurisdiction of the High Court in the Constitution instead of amending that part of the Constitution by expunging the word supervisory? I admit this may be a matter for Parliament." When you did your slide and you were comparing Article 131 with 140, you crossed out supervisory just to show, for the purposes of teaching, the difference between the two. But apparently, he understood it to be is something that should be crossed out in the Constitution. Do you understand? It doesn't appear.
I think that the crossing out of that word, supervisory, yes, it's most like I have great respect for the legislature. I'm finding, I mean, as a judge, that um, you need to bring your mind to what it is that they were looking for. And when you do a review of the case law, especially um, uh, even going back through common law jurisdictions, you will begin to appreciate why particular words are used in that way. And I think that in this situation, I mean, I haven't been confronted with it, but off the top of my head, I would imagine that it may well be because the High Court jurisdiction is wider than the Supreme Court jurisdiction.
The next question we have says, "My lady, please, why was Order 42 of CI 47 repealed by CI 133?
Thank you for the question, but I'm not on the rules of court committee. And I suspect that it may well be a lot of the befuddling. And then I think there's this decision also quite recent. One of the last decisions of Justice Benin, Justice Benin wrote that decision on the Supreme Court, where the court held that if a party files, I think in that particular case, ex parte in Saki or something. I'm trying to recall the name. But in that case, the party filed a review, and the review application was dealt with very quickly. So he was not out of time for appeal. And so after the review decision, which didn't go his way, he appealed. And he appealed against the original decision. So when it came to the Supreme Court held that if you exercise the right to appeal, to apply for review, then you can only appeal against the decision, the review decision, but not the original decision. Are you getting it? So the original decision is, let's say, on the 1st of March. Then you apply for a review, and the decision on your application for review is, let's say, on the 18th of March. And you find that you lost that one. So you may still have time for the to appeal. Then you file an appeal, but you file an appeal against the decision of 1st March, not the decision of 18th March. The Supreme Court held that once you have applied for a review, it is only you've taken a step, and it is only the review decision you can now appeal against, and not the original decision. Which really, then, I think by the end of it was time to put this confusion to bed on when you should, because I mean, all of us telling the truth, most of the time the review applications are made as a shortcut, isn't it? They're used as a shortcut to changing the mind of the judge. Just like sessionera is often thought of as a shortcut. But I hope that after this afternoon you won't think of it as a shortcut, because I think a lot of people tumble down.
The next question says, my lady, please, is the 90-day limitation My lady, please, is the 90-day limitation to invoke supervisory jurisdiction in relation to 90 working days, or that includes weekends?
It includes weekends. Yes. There's a way in which time is counted. So if you know how time is counted, it includes weekends. You give yourself a lot of trouble if you take out weekends.
So in the absence of any further questions, viewers, thank you so much.
I'm discharged.
Thank you very much, Her Leadership, Susanna. So that brings us to the end of today's session. I would like to remind everyone that His Lordship, the Chief Justice, has expressly written to us to exclude lawyers from who are joining this conference from attending court. Some of us are getting complaints. Any lawyer who intends to join this conference is exempted for court attendance, and his lordship has written to the bar to that effect. Yes, yes, for tomorrow, So tomorrow's session will start at 9:30. That's 30 minutes earlier than today's session, 9:30. And the morning session, we'll be looking at witness statements as evidence in chief and case management by judges under CI 47 as amended by CI 87, challenges and solutions, and also disclosures and due process, an examination of the right to silence in the discovery process and case management criminal proceedings in Ghana. And our national PRO, Mrs. Ya Jacobo, would be the moderator. The speakers will be His Lordship Justice Martha Sound, Justice of the Supreme Court and Senior Lecturer, Ghana School of Law, Justice Dennis Dominic Eji, Justice of the Court of Appeal, Senior Lecturer, Ghana School of Law, and Fellow of the Ghana Academy of Arts and Sciences. The afternoon session, session 1, Social Media and Ethics. Where do we draw the line? Justin Agbeli Amenuvo, Managing Partner, Amenuvo and Associates, will be the moderator. He will not be cross-examining anybody tomorrow, so don't worry about that. Celebrity law, that's what I hear. Yeah. And his image, his facial image on social media will not be evident tomorrow. And the speakers will be His Lordship Justice Nene Amegacha, Justice of the Supreme Court and former National President, Ghana Bar Association, and Mrs. Victoria Bath, Managing Partner, Samoku Jeton Associates and Lecturer, Ghana School of Law. And the second session will be on maximizing client care in a virtual world. and the impact of COVID-19 on justice delivery, virtual hearing versus in-person advocacy. The moderator will be Dr. Kweku Innocent, Senior Lecturer, University of Ghana School of Law, and the speakers will be Justice Ellen Vivian Amwa, Justice of the High Court, is Anan Ankoma, Senior Partner, Binti Inchil Lecture and Ankoma, and the National President will give us the closing remarks. So please take note that tomorrow we'll start 30 minutes early, 9:30 a.m. Thank you and we like everybody to know that we had 531 people joining for the morning opening ceremony and the plenary session, and 337 join this afternoon. We hope to have everybody tomorrow much. And Treasurer to give us the closing prayer. Miss Nanasewa Echam.
Can we be upstanding for closing prayer? Our Lord and Heavenly Father, I want to thank you once again for a very successful first day of this Bench Bar Faculty Conference. I want to thank you for for being with us throughout everything that we did. We trust that, Lord, you'll be with us even as we continue tomorrow. We trust that even as we leave here, we do not leave your presence, but that you go with us in our various ways of leaving here. Take us home and then bring us back again to continue this session. In the name of our Lord Jesus Christ, we pray with thanksgiving. Amen.